Norman, are we ready to go?
Yep, you're ready.
Great. Well, good morning, everyone, and thank you for all of you who are letting me see your sweet faces. I really appreciate that. It makes it so much better. We've got a lot to cover today, and so I don't want anybody to feel overwhelmed. We just take a nice deep breath. Change is good, right? That means that we're doing well when we have changes, and boy, do we have some changes. So I'm going to get going on the PowerPoint right now. Okay, so what I'm going to do today is I'm going to talk about, I talked about the Senate Bill 140, the mass marketing issue, for a lot of the session. So I'm not going to mention that again. We're kind of past that. Everybody's on board on that. I am going to talk about the Senate Bill 3611, which is the signage fines and public right-of-way, those type of things. And then I'm going to talk about the Senate Bill 17. This is relating to acquisition of real property by certain aliens or foreign entities. And so I'm going to show you, I've given you copies of the law that was enacted and went into place September 1st, but also the information from our Texas realtors regarding it. And then I'm going to show you the Texas realtors proposed form changes. As I said, when the TREC contract was proposed with changes, the TREC seller's disclosure, all of those things are in compliance with laws that were passed. And so Texas realtors provides our private agreements, right? Our listing agreements, our buyer tenant agreements, our leases and commercial, and that TREC does not. And so Texas Realtor is proposing these changes based upon the TREC contract changes, as well as the result of Texas Realtors' involvement in lawsuits here in Texas regarding the various areas that were also in dispute under the NAR settlement. And then the last thing I'm going to do is I'm going to touch upon 10 highlights that buyers who are interested in new construction, right? That we probably need to just make an understanding of it. They are so different, new construction builder contracts. And so that's what I'm going to do is I'm going to point out the areas where we've had issues, where our buyers have come back to us and think that we're supposed to resolve all of these things between the builder and the buyer that we represent. So yes, okay. So the first one is the signage. Now, it's always been against the law to place signs in public right-of-ways and those type of things, or in property that we don't own. That's always been. What this bill did was significant increase in giving the local municipalities and authorities teeth in fines. It set up the first violation is $1,000, the second one $2,500, and then $5,000 for a third and subsequent violations. Big fines. But what it also included, which is what the concern is for you, is that any business advertised on these signs is liable for the penalties. So, you know, when you place a sign, many of our little signs that we have would be open house signs, what we would call directional signs. They're including that. Be careful about where you place them. Make sure that they're not there for any extended period of time as well. Every municipality or county is different. I know that from the Houston area. The agents at the Woodlands told me about the signage issues and those type of things. Where I live up in the hill country, if it's out in the county, they don't care. But boy, if you were in the city of Bernie, they do care on something like that. So while it's always been against the law, we just need to take precautions to make sure if we place a directional sign, that we also remove it promptly, right? That it doesn't stay there and grabbed for violation, because any violation the brokerage is going to get, you're going to pay for it, okay? So just make sure that you pay attention to that. The other thing I'm going to mention to you, we used to have some areas where on a corner. It was a perfect vantage for us to place our directional sign to our open house, right? And sometimes the agents, listing agents, the ones hosting the open house, would put it in an area on that corner lot where the seller of that lives there was very offended by it. They felt that was their property and they didn't get permission to put that directional sign in that. So just remember common sense and courtesy here to others. You could always ask your seller, could you please contact your neighbor down the street and ask them if it's okay if I put my directional sign there from 12 to 4 on Sunday. Those types of things. Just kind of think before you place something that might cause events. As I said, we knew certain areas were very sensitive about it and subject to it and those types of things. So again, it's always been against the law. It's just got a lot more teeth in it as far as fines go, as well as now coming after the business that happens to be on the sign. Senate Bill 17. Now, this has caused major uproar, and it's relating to prohibiting sales to some foreign entities and individuals. Those are entities and countries that are on a list of the national security list, and the governor has the ability to also place them on a list, certain countries and those type of things. And I provided you a copy of the law. I read it. I had an agent a couple of weeks ago that was in a horrible panic. He goes, I have a prospect from California and they're not a permanent green card holder. They're here on this temporary type basis and all these types of things. And he went in and Googled a bunch of stuff, which was not accurate, right? And some of that Google garbage said that the realtor had to vet that, which is garbage. Texas Realtors published that, and we'll look at that in just a minute. But what I am going to tell you is that we really need to understand that we're not going to legally advise individuals that we might represent for purchase or lease. What you don't have to worry about is if those individuals that are not U.S. citizens or permanent green card holders, if they claim that property as their homestead residence, they're exempt as well. The issue could come in if the individuals want to buy residential rental properties for their rental portfolio. That they have to be advised to consult an attorney. We don't do that for them. We don't interpret it and we don't vet it. And I'm going to show you based upon what we've got. Okay. Can everybody see the restrictions on foreign acquisition of property?
Yes.
Yes. Thank you, hon. I sure appreciate you doing that. Appreciate it. So Texas Realtors published this for a reason, and this is going back over a month or so ago before it went into place on September 1st. And the state legislator brought it, and they really wanted to bolster the security by restricting certain transactions, right? And it prohibits certain real property purchased by countries or entities. And those are countries or entities that are on this annual threats assessment by the U.S. government or the Texas governor, right? So it is subject to change at all times on something like that. It does provide civil penalties, create a criminal offense, and gives investigation and enforcement authority to the Texas Attorney General. The Texas Attorney General is the only one that can bring something forward on this. This is within their bounds on being able to undo or fine or investigate these types of transactions. Restricts entities and individuals from the designated countries to leases of less than 1 year. Okay. It includes an exemption for all legal U.S. citizens to purchase a homestead. Yeah, that's true. That would always be the case. U.S. residents are exempt from all of this. And the last one that I highlighted said that it does not require real estate professionals to screen purchasers. So that means that you're not going to be giving them any advice. That's not your job. What I am going to tell you, several months ago when this law was passed and signed by the governor and we knew it was coming into play, our attorney Stephen Rogers and I visited regarding language that would need to be added, right? That would show that we had advised the buyers and tenants properly. And the Texas Realtors responded, and we'll see that when we look at the revised buyer tenant agreement on something like that. Again, it's not your place to screen it. The purchasers are the tenants. So again, be very careful about not overstepping your boundaries. There's a reason for all of this. Now, what they did say is that they remain neutral on this bill. And Texas Realtors chooses which bills they're going to become involved in making sure that they protect real estate professionals and their clients from any liability and defending fair housing laws and that type of thing. So again, this was the advisement that we understood. They have added in our buyer tenant agreement the proper language that needs to be there if anyone we represent might have reason to think that they could be subject to this new law on something like that. Again, it's not our place to vet it. The language is there. And when you review the buyer tenant agreement, as you do with all your buyers, that paragraph will be there. And if it applies to them, they'll see it at that point in time, the advisement that we offer that they should seek legal counsel and something like that. Okay. So now what we're going to do is look at the proposed form changes. TREC's Broker Lawyer Committee meets on October 10th. So we will update you. We're going to have a meeting that's going to be mandatory so that you understand everything that's going on and those types of things. Because what happens on that is once the TREC Broker Lawyer Committee meets early October, they will determine that all those proposed changes that TREC provided them in August, they review all the comments. I mentioned to you about, making sure that if you don't like certain provisions or you think something needs to be done differently, you put that advisement in there. They look at all of that, the Broker Lawyer Committee does, before they agree to approve any of those proposed changes to the forms that we have. So what does that mean? That means that if the Broker Lawyer Committee approves all of these, we know for a fact the IABS will be approved because that goes into law January 1st. But what that means is that when TREC meets on November 4th and they approve all of this, then that means we have the clock running for when we will have to be required. They will be mandatory for use. And what we usually see is it's early November, they'll approve them. The third party will have them in the libraries and updated usually towards the end of November at the very latest in the beginning of December. Once they upload it and approve it, you can use it. It will be mandatory for use as of January 1 on something like that. So just kind of pay attention to that. Texas Realtors, they have proposed all of these changes in tandem with the laws changing as well as the forms that TREC is changing and what has happened in lawsuits regarding better form creation and revisionaries that we might see on them. So we'll look at that. There are a slew of lease forms changing. We're not going to go into those in detail until we really have the contract portion down pat, but I have provided the summary that Texas Realtors gave. They couldn't do a red line because there were so many, so they gave you a summary of the text on it and then what they're proposing for the changes based upon the laws that had changed. So again, those will all be the minute Texas Realtors approves the final revisions on that, you'll be notified and then you will be required to use them. I'm going to show you two new forms, and one of them, the showing form, I mentioned to you that in the IABS, when we went through it in detail and the requirements, they said that you couldn't have a showing form with no representation for more than 14 days. Well, our current short form that has showing full services or showing services had a beginning date and an ending date. So the showing form will be used for those that are going to need to have a prospect see a property. You'll give them the IABS and then the showing form, and we'll go through that. The other one is the new Form 1958, which is the residential contract critical dates. There's always been one for commercial, so they added one for residential. I also provide the Excel spreadsheet, which does automatic calculations based upon what you will fill in the beginning, the executed date, the closing date, and those types of things. So I'm glad that they saw that, mainly because they understand that buyers are not sophisticated enough to pull the dates from all the contract as well as the various addenda, as the license holders are, as we are, as the realtors. So they created that. Then I will show you the proposed changes on the HAR 300 on something like that. Again, once I pull up some of these, I've given you a list of all the forms that are proposed, and I am going to pull that up now. Okay, so on this form, you see how they've got which ones they have drafts on for those types of things. Some say final draft on something like that. Final draft means that what they have approved that final draft, and it'll be going in. Again, these are all various forms that will change. When you go to the Texas Realtors website and you look at the forms under revision or proposed changes, they actually give you a comment area. So after today, if you have a comment regarding something that you've seen or reviewed, please do that. They look at all your comments and take them very seriously on something like that. Okay, so the first thing I'm going to do is share the HAR 300. We're going to do that first, okay? The form changed because it needed to be updated and really reflect the type of marketing that a seller may choose for options, right? And on this form, they have defined the 3 types of sellers options for limited marketing. When you put it in MLS within 3 days after the beginning date, this form is not used, right? Because you're already in MLS. This is for properties that may have a different designation in MLS or may not be in MLS, as they're going to explain. So the first one is office exclusive. It's not displayed to other brokerage firms in the MLS. There's no public marketing on something like that, and it has limited exposure. So the sellers need to understand what it means, that you're not going to be out there, doing anything, public marketing, signs, flyers, social media, online promotion, none of that. The second one is private per seller. And we've had this status in MLS for a while, but they wanted to explain the category of private per seller. It's in MLS, but it's only visible to those real estate professionals and their clients that have access to MLS, right? It won't be displayed on HAR.com, other websites consumers use to search for properties for sale. It's limited exposure. Public marketing is allowed by the seller and listing broker, okay? But the final selling price is not required to be reported unless the property was previously listed in a different MLS category. So it truly explains to a seller the option if it's private per seller. Now, coming soon, we've had that based upon the clear cooperation policy that went into place several years ago. And what it means is that it's going to be entered into MLS. The other real estate professionals and their clients know that it's coming soon. It's only in there for 21 days, then it automatically goes to active. And public marketing is allowed while in coming soon status, but no showings. Showings only occur when it's in active status on something like that. Then the sellers will mark one of their boxes, the sellers will sign and date it, and then the listing agent signs and date it. No more tracking this down or getting the broker, the team leader to sign these forms. which is a great move, truthfully. It should have been that way all along on something like that. Okay, so now we're going to look at some drafts of the various forms. And I think I'm going to take the listing agreement first, and then we'll go to the buyer tenant agreement. Let me change this up a little bit. Okay, now this changed significantly, but there's a purpose in the way that they were trying to reorganize the information. The first one is paragraph 2. Oh no, Marilyn, they're removing all the improvements, accessories, exclusions, and about owners. No, they moved it to paragraph 8. So it's still in the listing agreement, just it'll be in a different spot on something like that. The list price is only going to be what, don't put a range in. Sellers have to make a decision, and it's based upon their estimated net sheet for the list price and all of the cost associated with selling the property for that list price. Once that's done, it's there. It's not a range. It's a real number. You don't get to do anything until you and the sellers agree in writing on those various things. So again, it's very important to truly understand the reasoning for these types of things, making it simple, try to make it more simple, get rid of various other extraneous language. Then for term, it's just now going to be beginning and end. Well, you don't have a listing agreement until it begins. I don't care when you and the seller signed it. The beginning date is the critical part. That's when you begin and have an actual listing agreement. Now in paragraph 5, you're going to see something very different. You're going to see that there's only one option in 5A for broker's fee. And they say in parentheses, broker's fee is not intended to include compensation to a buyer's broker, okay? And the reason for that is they looked at the various components of all the filed lawsuits. And sellers are saying that because you, Texas Realtors, give an option for the seller to pay the compensation, you have colluded, you've inflated compensation, the cost associated, all this stuff that we know is not true. But the form did change. So there's only one paragraph in 5A regarding compensation, and it's not intended to include compensation to a buyer's broker. The reason for this is they want full, clear, transparent understanding by a seller. Over the past few months, since I've seen firsthand that agents don't know how to use the TXR 2402, they don't know how to use the contract, they don't know how to use page 7, the disclosure, all of these things. It was revealed to me that our current paragraph 5B, which is only broker's fee, we don't have authority to share any of that, was the way to go. It just was the easiest way because we get pushback from other brokers that don't know what they're doing. We just needed to be real clear about this with the sellers. In other words, the sellers will determine that when they receive an offer. And that's when our contracts changed last November to include 12A1B as the provision where a buyer could negotiate with the seller to pay their buyer's brokerage compensation. So again, it's proposed to remove all of that. And then the remainder of the paragraphs are just relettered based upon getting rid of the 2 paragraphs, 5A and 5B, and only having one 5A on something like that. The other thing that you're going to see not only here in the listing agreement, but it's going to be reflected in the termination agreements. It's going to be reflected in our buyer tenant agreement as well and other places, is they are defining what a protection period that the listing broker may apply in the event that they have an expired listing or they terminate the listing. And so they explain to the seller what the related party means, so that there's none of this seller saying, well, it didn't say that I couldn't have my family member act on my behalf and take the property, all these different things that were done. So it's a clear presentation to us sellers, that this is what protection means. In other words, if you go behind our back, we are protected on something like that. And the protection period has a number of days, right? We're not protected if they list with another broker unless we have our termination form, which does give us other provisions for till the end of our current listing agreement on that type of thing. And then they added clear, if a related party of seller agrees to sell all or part of the property during the term, subject to the provisions of paragraph 5E, broker will be entitled to all compensation under this agreement as if seller had sold the property. So again, it's one of those things going behind the back and doing something. We have an exclusive agreement with them. They don't get to do something like that. And so they just have language that's more attuned to that. They stopped using the whole multiple listing services and just used the MLS because that was defined earlier in the agreement. So they didn't need to repeat it on all of those things. The next one is based upon those paragraphs in 2 that we now see, the improvements, accessories, exclusions, and owner association. They're now in paragraph 8, the additional property information. So it's still there. It is still subject to sellers understanding what they are conveying and what's included on the property, as well as the owners association and any exclusions that the seller may want of their real property. The next change is really about what the responsibility is of sellers, right? They have additional promises in paragraph 13. And J has been added so that a seller knows that when you sell the property for the listing price or any price agreeable to you and pay all typical closing cost charges to seller of residential real estate in Texas, seller's typical closing costs are those set forth in the residential contract forms promulgated by TREC. So when TREC made those changes in paragraph 12A, defining what the seller's expenses are, they had to incorporate that. It's a good thing to incorporate that in their listing agreement so the seller is aware of it at time of listing, not just when they receive the offer for their property. The next thing that you're going to see, other than changing out the T47.1 declaration and that type of thing, is that it's not a change, but it tandems with if we represent a seller that's a foreign person as defined by federal law. And 21H actually includes what the definition is, so they always know. The seller marks about they're either is the broker that seller is or is not a foreign person. If they are a foreign person or it's a foreign entity as defined by federal law, we would need to make sure before we list that property that the seller has provided to us their tax implication, and that will be done by their seller's tax professional or an attorney that would advise them this would be your tax implication for selling this property under the FERP law. Okay, that's that federal taxing authority. So why is that important that we have it? It's important that we don't mark this box, that the sellers mark it, because they're the ones who are going to be responsible for it. The second thing is we can't do an estimated net sheet for the seller until we know what their tax liability may be or may not be. Make sure when you do it on the estimated net sheet, you put per seller's attorney, per seller's CPA, whatever the source is, so that it doesn't look like you did it, right? Because that's stepping out of our boundaries on what we can do. The other thing is, if you have a property where the seller is subject to that, you will have to make a notation in agent remarks. All buyers need to know this prior to going in and presenting an offer. We had a situation where buyers get very upset when they find out that they have to take those tax proceeds from the seller, and then they personally will have to put their own social security number on the forms and send it to the IRS. And buyers need to know that, because some buyers feel that if they weren't told ahead of time, they never had any idea that they were going to be implied as far as their tax ID when they send all the forms to the IRS. They didn't really want to be a part of that. They would have preferred knowing that before going in. So make sure it is marked an agent remarks on something like that. So it's important that the broker statement still be there. Consult an attorney. Broker cannot give legal advice. This is a legally binding agreement. They put a little bit more emphasis on defining some of those areas where they had been maybe not as strong with the language, so that the seller really understood that they could be in breach of our agreement. And again, if you don't understand the effect of this, you are going to what? You're going to consult an attorney, sellers. It's the same thing that we have on most of our forms, that we advise them to seek legal counsel. We don't give legal advice on something like that. So again, this is the proposed change. It's not the final draft. They're really waiting for the Broker Laureate Committee to approve many of the changes that are reflected here, but it's still under revision. It's not the final draft on something like that. So make your comments to Texas Realtors regarding this. Okay, the next form we're going to look at is the buyer-tenant agreement, okay? And what you're going to find on this agreement is that language that I mentioned about the Senate Bill 17, where we don't vet our buyers or tenants, but they needed to know what they had to be advised of the information that they may need to seek legal counsel on if it's subject to them. Please don't leave any parts of the client's information. Your broker has to have full information. I cannot tell you how many times the phone number is missing. Well, great. Then you can't text them. You don't have permission. Since the Senate Bill 140 was done, everybody is asking and giving that same banner about, you're giving me permission to contact you by providing this information. In other words, when I give my email, I am verifying, and they're asking and saying, you've given me permission to contact you. Your broker has to have a record. I cannot tell you how unfortunate it is when we don't have this information completed by our agents who are representing these buyers or tenants. So make sure you complete all that information. Give your own information too. You're not going to leave that blank either. You have to have a means by which they communicate with you as well. The biggest change that you're going to see is in paragraph 7. Okay, and they struck out some and just said that the compensation, it's not set by law, but it's fully negotiable, and you see that in a lot of areas, right, on the language regarding that. In paragraph 7A, they have the broker's fee that we have right now, but what they added was paragraph 7B, which is a retainer. Personally, I've done this presentation with a lot of brokerages, and it is really important that we have this provision. There have been clients that we've been over backwards and showed them property and everything, and the next thing you know, they're not saying, well, I just terminated. I'll take some time. I don't want to look any further. And you've already spent a great deal of your time and talent on this, right? So here's what the retainer says. At the time this agreement is signed, client will pay broker. At the time the agreement is signed, client will pay broker a non-refundable retainer of X number of dollars. Broker will or will not apply this retainer toward any other fees owed to the broker under 7A, right, which is right above there. When broker receives payment of the other fees under 7A, client agrees that this retainer is reasonable and is being paid in exchange for broker's time, resources, and services provided to and on behalf of client. Client understands the retainer is fully earned by broker when paid and will not be refunded to client, even if this agreement is later terminated. Depending upon the election above, which is the will or will not in this paragraph, the retainer will either be applied as a credit toward other fees owed to broker under paragraph 7A or treated as an additional fee earned by broker under this agreement. I think what we are seeing in all the various changes in the last few years, buyers agents appear to not be doing much work, right? When we do a tremendous amount of work behind the scenes for these buyers. And we've had instances where you've expended, you have a buyer tenant agreement, you've shown them properties, you provided all this information. The next thing you know, they said, I decided I don't want to go forward. And you just showed them, 25 houses, given them a wealth of information that you did behind the scenes, a lot of work on something like that. So I like the fact that we have this provision. I think it's very important that buyer agents also feel that their time and talent is worth something, right? That they are not going to be abused and then said, oh, well, case in point, one of the agents told me, he said he put 1,500 miles on his truck showing farm and ranch property, right? And he said they were under contract, found the property that really met their needs and all of this. And he said a day before the termination option ended, they decided to terminate and told them they're not going to do this anymore. And he'd already spent so much time and effort, cost to provide access to these properties and his fiduciary duties to them. And he loves it on something like that. So again, it's a powerful change. I think it's well overdue, truthfully, on something like that. But it is that additional option that you can negotiate with your clients, your buyers and tenants on something like that. The other changes are just minor as far as language goes and that, but in the protection period, remember the one that was in the listing agreement, they have added what the definition is of a related party as well on something like that. So again, just needed to kind of standardize between all the forms, the definition of related party for the protection period on something like that. Then the next change was in limitation of liability. Well, there were some sellers who said, well, you said broker, but that's not meaning your agent, right? The broker's associate. So they had to add that because it had to be explicit so sellers couldn't use it against us, that it was the limitation of liability by the broker, et cetera, on something like that. And then what you're going to see in the new paragraph 18G is the Texas Property Code in compliance with the Senate Bill 17, right? Texas Property Code Chapter 5, Subchapter H restricts certain individuals, businesses, organizations, and governmental entities linked to countries identified by the Director of National Intelligence or designated by the governor as a risk to national security from purchasing, acquiring, or leasing real property for a term of 1 year or longer. If client believes the restrictions may apply, consulting with an attorney is strongly recommended. So we're not an attorney. We don't have to vet our buyers and tenants. But if this applies to them, they will do well by making sure that they consult with an attorney on something like that. I am going to tell you that the Senate Bill 17, as I mentioned earlier, there's been one lawsuit. It was dismissed because the judge said they didn't show damages. Another one was submitted just a couple of weeks ago. It involves a Baylor University student here on a visa and was filing it that it was an undue burden for him to move because he couldn't have a lease term of 1 year or longer on something like that. So stay tuned to that when we have a ruling on that. regarding it. And again, as I said, you're not the person that's going to vet it. The only one that can enforce this is the Attorney General, right? On something like that. So just understand how that impacts you in the course of presenting your fiduciary's duties to your clients. Okay, the next form I'm going to look at is just real quickly, the termination of the buyer-tenant representation agreement. We use this more, unfortunately, than we do our termination of listing. But I love the notice at the very top. It says this termination is only effective when signed by both client and broker. Okay, why is that? You don't have an agreement. These are bilateral agreements. That means that the broker and the client must have signed it or you don't have it. For instance, that's why you pay attention to you making sure you initial sign and date your buyer tenant agreements at the right time, same way with your listing. They also talk about a broker's fee, and they add that language that client and the broker have determined that this termination fee is fair and reasonable, right? Some of the same language that we saw in the buyer tenant agreement regarding various retainers and stuff like that. Talks about the protection period, linking it back to what's in the contract, the buyer tenant agreement regarding what a related party is. And then the release in this termination that we're now, once we sign this and the provisions are actually enforced and upheld, it is a binding obligation between the parties on something like this. So you see how almost every form we're looking at has changed, reflective of what our buyer tenant agreements might be, or our listing agreements on something like that. The next one I'm going to show you is the seller's disclosure. And I'm going to tell you that when the law changed, and we saw that when we did all of the proposed contract forms as well as the seller's disclosure, Texas Realtors provides a disclosure that includes everything mandated by law, and then those additional areas where brokers throughout the state of Texas have told them, Texas Realtors, look, we've had these lawsuits regarding these matters. We need to incorporate so that the seller has provided better disclosure to a prospective buyer. What you're going to see in particular are the changes on this form that reflect what you saw in the TREC contract forms, the TREC seller's disclosure. We only use the Texas Realtors one because years ago we had a listing agent on the stand, and the plaintiff's attorney, who represents the buyer, asked the listing agent who provided this form to the seller. And they said, I did. And they said, why did you give that form to the seller? And they said something, and then the plaintiff's attorney said, is it not a fact that your association has incorporated a form that would allow your sellers to disclose more than what is minimally required by law by TREC's form? And the listing agent said, yes. Well, we were doomed at that point because it looked like we had made the decision. Your broker has the right to say, look, in my experience, these are my requirements, and they're there for a reason. No seller has ever been sued because they disclosed too much. Okay, so just keep that in mind why we do this. Once it changes by law and the form is used, then you have to go back to sellers who haven't sold their property yet and get the new one completed so that they're current with what has been changed and reflects the requirements of making sure that our form at Texas Realtor complies with the law, which that's it. So in section 3 rather, they added previous roof repairs or replacement. Clarity a little bit on something like that. They've also added a private road on or adjoining the property for which you seller is responsible for maintaining. They felt that very strongly that a buyer or prospect needed to know this before they would submit an offer. Any subsurface structure or pits, right? The other items are underground storage tanks, above ground storage tanks, and above ground storage tanks on the property and hold 500 gallons or more and have stored petroleum products or other chemicals. Those that are asterisk, those double asterisks, they are, if yes, you're going to see the administrative code requiring the various additional disclosures that are required regarding those types of tanks that are there. So again, it's important to note that when these changes happen, it's reflective of what? The lawsuits and the laws changing on something like that. The next thing that you're going to see is in Section 8, we had a big, long, currently, a big, long list of various things. You're going to find that now is going to be in Section 11 of the seller's disclosure. But in Section 8, the sellers have to say if they're presently covered by insurance, if the property is covered by windstorm insurance, or if the seller has been unable to secure the insure of the property for any reason. Those are additional fields requirement. Again, Section 11, which was the continuation of a lot of different questions that the sellers were asked. And you'll see that the few that are taken out, they'll be in a separate area. They're still disclosed about the association and any of the common areas. But it added that conservation easement located on the property. We saw that in the contract form as far as disclosing various things in paragraph 7. It's a new paragraph that was added to the TREC promulgated form. And then it says if you answered yes to any of the above, you need to explain it, okay? The next two questions are directly related to the homeowners association. You notice how they took this homeowners association information away because you don't need to say yes again and explain it because this is the statements. If yes, complete the following and the information that's all there that the seller needs to complete. Again, the rest of the sections are renumbered to fall in line with all the additional various sections that were added to the disclosure. And so we have a situation where a lot of listing agents hate to go back to their sellers who haven't sold the property once this becomes mandated for use because it complies with the law changes. But it is there to protect the sellers on something like that. And I'm going to tell you, I've had several brokerages that use Seller Shield for their clients to complete the disclosure. And one of the broker associates, 91% of his sellers all complete it through Seller Shield, the free wizard. And he does that because it's been proven to him. He had 3 sellers who were sued, but he wasn't named because Seller Shield was on the seller's disclosure, and the plaintiff's attorney knew that the listing agent had nothing to do with the sellers completing the seller's disclosure. So again, think of it both from a standpoint of protecting your sellers because they have a wizard that can advise them on various fields if they don't understand certain things, and that you're not involved in it. The moment you answer one of their questions about the seller's disclosure, it is now your disclosure, which is really a very tough thing to do. Okay, the next one I'm going to show you is the compensation agreement between brokers. There's just been one change, and it's at the very top. It says, note, do not use this form without written authorization from seller for listing broker to share compensation with cooperating broker. And the reason for that is because this compensation agreement is between the brokers. A broker can't share compensation under the new revised provisions of the proposed listing agreement because it says no, it's not intended to do that, right? But if you have permission, which we have a lot of listing agreements that are still in force, this agreement is not going to go away because the sellers have agreed on the current listing agreement to share compensation with the other broker. This has to be completed entirely. Completed and done prior to what? The buyer submitting an offer, because the buyer is obligated to know, I owe the compensation to my buyer brokerage, but I need to know if it's going to come from another source, which is in the contract of the buyer tenant agreement in 7B. Okay, The next thing we're going to look at is the showing form, the new form, right? Showing form. And why did Texas Realtors provide this? Well, because on the current IEBS proposed changes that are going to go into effect in January, it says, consumer, you don't get to see a property without a realtor or an agent, right? Agents are those that are not realtors, right? And so what it did was it leveled the playing field for those that are not realtors to be under the same aspect as those realtors because of the NAR settlement. And it talks about the showing form that's used. It says, you're not represented. I don't get to charge you for showing you this property. I can't give you any opinions and advice. There's no other brokerage services that we're providing. My only thing is I can tell you the size, price, and other terms concerning the seller lease of the property that an agent, a realtor would have if they had the MLS information, right? Or they had been provided that limited information. The term, it ends 3 calendar days from the last date initialed below or until such time as the broker represents customer as customer's agent, whichever occurs first. And what that means is that you can show them that, and then if they get all excited and love you, even though you've given no opinions and advice, you'll turn around. If they want you to represent them, you have to turn around immediately and do the buyer-tenant agreement on something like that. The representation disclosure, it says that the broker will disclose to customer if broker represents the owner of any property accessed by a customer. We need to say that in the TXR 1417 as listing agents. That's the form that we use along with the IABS when we have a prospect. So they absolutely understand, I don't represent you. I have no fiduciary duty to you. I only represent the seller or the landlord. The limitation of liability was added because of the issues that sometimes when you show a property, there could be a hazardous situation and they fall or they do something that they're going to hold you harmless. We are not responsible for their safety. They need to be aware of their surroundings and making sure they understand that we're not responsible for that. So they added that. By initialing below, broker and customer acknowledge and agree to the above. The license information, our initials, then the customer's name, right? And then the customer's initials and date. Okay, so these are real critical as far as satisfying the new requirements under the law by the information about brokerage services on something like that. The next one is that residential contract critical date list. I mentioned that we've had it for commercial for a long time. Well, this is what is applicable to our residential contract. You'll see that it has the most common use of the third-party financing addendum on it. It might have other types of information that it's on, but in my Excel spreadsheet, I've also included the HOA because the third party and the HOA are the ones that we have the most common types of addenda added to our 1 to 4 family contract, various other things. So again, you get to complete this and use this and provide it to your client so that they are aware of it. As I said, buyers have a very difficult time pulling things out of these various things on our contract and our addenda, the time limits on something like that. Okay. So now we'll get to some questions regarding those after I finish the presentation for the builders, okay? And we'll get to all of your questions that you might have. Okay. Boy, this is the time of year. If you have clients that are interested in really wonderful opportunities from builders, I get them every day, and so do you. They are offering sometimes a very low interest rate for those buyers that are financing. There's other benefits. The builders want to get all of these units they need to close by the end of the year and off the books. That's just how they work. And so at that point in time, your buyer really benefits from that. But the buyers need to kind of understand some things and understand that builders' contracts are created to benefit the builder. TREC contracts benefit what we would call the consumers, right, on something like that, but not the builder's contracts. All the builders' contracts I go through, each one has various provisions. Some of them have certain provisions, some of them don't. You don't get to legally interpret it, but you can tell the buyer, look, if there's anything, you need to read all of this. If there's anything you don't understand, we need to get clarity and make sure it's in writing for you on the contract, because the only thing that is going to be binding between you and that builder is what all the parties agree to in writing, right, on something like that. So I'm going to mention a few things that have been placed in some of the builders' contracts. Number one, builders are requiring a buyer to provide their buyer-tenant agreement. They actually gave permission to the builder and said, I will provide it to you. You think the builder wants to be the new police if we've done the right thing and had a signed agreement before we showed him the property? Could be. They could be looking at it, they're going to protect the buyer, or they could look at it and say, I'm not going to give you compensation more than what you agreed to in your buyer-tenant agreement. You just don't know. So I just wanted you to be aware that's there. We've already had requests that have come from lenders, and buyers have been asked by the lender, I need to see your signed buyer-tenant agreement. And the buyers have said, here it is. Because they have been asked to provide that from their lender. The real clear thing here is on most of the builder contracts, they either have it built in your compensation and who it's going to be paid for and the amount, and then the buyer initials and dates that, right? That's documenting that the buyers approved it because it's right there in the contract. Sometimes it's in a separate agreement that's attached as the agreement to that builder's contract. Whichever way it is, we have to have it. The broker cannot issue you a DA, a CDA, until we know that you have been what? Who's paying you and how much and those types of things. So, and that's the same all over the place. If you don't provide in your contract forms for TREC a provision in 12A1B to get paid, you have to provide it in a separate agreement, which is the compensation agreement between brokers, or your buyer's paying it, but it's only going to come from certain sources and the broker has to see that. Otherwise, they cannot issue you a DA for compensation. They don't have one. They don't have proof that you, who's paying you on something like that. The next one is privacy policy and consent. You know, I mentioned about making sure you complete all the information about your clients, the email, the phone number. The broker has to have a complete record. They can't have a buyer or tenant's name sticking up there and then nothing else. That's ridiculous. That means you don't have permission to contact them by email or by text or by phone, right? So make sure. But what I found in several of the builders' contracts is that they had gotten permission in writing from the buyer to have their preferred third parties like lenders as well as insurance companies, et cetera, contacting the buyer, right? We had buyers who came after our buyer's agent and said, you gave them all my contact information and I don't appreciate that, blah, blah, blah. And I told the agent, I said, well, let me see the contract. Well, it was clear in the contract the buyer had given them permission, but they weren't wanting to accuse the buyer agent of doing something like that. So again, just make sure they understand that they will be contacted if they have given permission, and most of the builders get that permission in the contract form itself. The other thing that is somewhat confusing for not only our buyers, but also our buyers agents is the terms that are used in a builder's contract. We're used to earnest money, right? Earnest money is deposited and controlled by whom? The title company, the escrow agent. That's not always the case with builder contracts. Sometimes the builder will take those monies and they even post a risk. When you give money to the builder, you're risking losing it and not getting it back, right? They even project that warning because based upon the contract, the builder may keep those monies in the event. The upgrades are never ever returned, but there are some things. Some of the builders use initial deposit, some use additional deposit, some use advance payments or upgrade payments, and then earnest money. And typically, earnest money is held at an escrow agent, the title company. What I am going to tell you is most of the builders' contracts state that, until we've received it, we don't have one. Okay, different than our truck contract forms. I had an agent who was texting me and said, on the builder contract, I'm really scared because the buyer is paying the money directly to the builder and they have 3 days. And I said, where do you get this 3 days from? That's not a truck contract. That builder clearly stated, until you pay it, you don't have a contract. Okay, so again, they were trying to equate the terms in our truck promulgated contract forms to a builder's contract, and you cannot do that. That's the issue you really need to pay attention to on something like that. 4, appraisal. Almost every contract I saw said that the builder is never going to reduce the appraised value to the sales price. They talk about some of them are blankets and will never do it. Some do afford allowances for FHA or VA. And some have said, they'll give the VA or FHA purchaser the ability to make up the difference, which they can, but they're not forced to go forward with it by the FHA and VA guidelines as they are stated in paragraph 4 of our third-party financing addendum. So again, you have to pay attention. We're so used to certain provisions in our promulgated forms, and we try and transfer them to a builder's contract forms, and that's not going to be the case on something like that. And there are notification requirements. You know how that critical date list that Texas Realtors proposed on that? There are critical time limits and requirements placed on a buyer to give notification to a builder on various things. So they have to pay attention to that. The buyers need to confirm with their lender. If it's a builder's preferred lender, usually they're in sync with the policies and everything in the contract form and that. Sometimes the lenders that are not the preferred lenders may have a gap between understanding what is contractually binding on their borrower per the terms of the builder contracts. But a buyer would always want to seek clarification on something like that before they go forward and sign a builder's contract that's legally binding. 5 is closing. In our closing, on paragraph 9 of our contracts, it says on or before, right? It doesn't have time is of the essence on it. Builders are different. Builders say closing will happen by this date when there's a time limit, especially at this time of year. Those units may be totally completed and they're ready to close on something like that. So there's various provisions, but almost all of the contracts said that when the builder goes to the buyer and says, we're ready to close, and the buyer doesn't close by the builder's required closing date, that buyers are penalized. Sometimes they lose the property. Sometimes they're asked to pay an extension fee to extend the closing. And those are charges and costs that the builder has by still having a unit on the books and not having had it closed when they were ready to close on something like that. Again, the buyer just needs to be aware of certain conditions regarding closing. The builder's in charge here. When the builder says close, you're going to close. When buyers use the preferred lenders that are offering so many incentives right now, it's unbelievable. They're usually in sync. See, they communicate, they understand the builder, they know it. Just same way with the title companies, the escrow agent that always closes the builder's contracts. They understand all of the inner workings of it and the time limits on that. What I am going to tell you is that when the buyer is not using a preferred lender, here's what we had the situation. The buyer agent gave them a list of lenders ahead of time because they wanted to make sure the buyer was qualified before they went out and went shopping for property. And the buyer agent has a lot of trust in this lender, rightly so. This lender has proven that they are upstanding and reliable, and when they say they're going to do something, it gets done, those types of things. Well, the buyer agent got contacted because the buyer went to that lender that the buyer agent recommended, and the lender said, "Oh, I'm not ready to close, right? We're going to need X more time." And the buyer blew up. They said, "I'm going to be punished by paying an extension fee because that lender's not ready." So again, you see why it's so critical, especially on these builder contracts, that you pay attention and help the buyer, making sure they're in touch with their lender and they're progressing forward so that they're ready for when the builder comes to them and says, "You got to close in 7 days, right? This is what we need." And a lot of times it's contractually binding. It's right there in the contract on something. 6, buyers usually are required to pay the title policy. In our contract forms, paragraph 6 has 2 boxes, right? Buyers or seller are going to pay it on something like that. But builders normally, in most of the contracts I saw, that they required the buyer to pay an buyer initial next to that provision on something like that. It doesn't mean it's not negotiable, right? So buyers certainly could try and negotiate something like that. Paragraph 7, this is an issue regarding utility boxes, and we've had them, unfortunately. And it's interesting because these builders' contracts are updated reflecting what? All the disputes that they've had, just like our TREC contracts are updated based on those, and our TXR, private agreements and leases and commercial. They're all sensitive to what has transpired, what has affected the realtors and brokers, so that we can incorporate better language, right, as they just showed in the buyer tenant agreement as well as the listing agreement. And here's what the issue is. Most of the contracts I saw, it says the builder says, "I'm not responsible for the utility boxes. Those come from the contractors for the utility company. I'm never going to guarantee where they are, and I'm not going to move them, and I'm not going to make a concession because now that it's built and the utilities are on site, right, for the property, you see the utility boxes are in a place you don't like, right?" That's one of the big issues that we have had faced. And I'll tell you a little bit more about directly related to those utility boxes, what happened in when the on-site salesperson said certain things. Paragraph 8, difficult buyer and buyer agents. Let me tell you, almost every contract has a provision that says if you become a pest or your agent, I'm going to terminate the contract. You're not going to get the property, and all you will get will be the original initial deposit or the earnest money. That's it. You don't get any upgrades or anything. You're out of here. And we've experienced that, unfortunately, firsthand. And this happened with a builder. We had a buyer agent who got an email from the buyers and said, "Could you please address this issue with the builder?" The buyer agent's a fiduciary. And so they went to the property, and sure enough, the builder was on site on the property, and the builder had a really bad day, and the builder had it with both the buyers, as demanding as they were, and blamed the buyer agent for it. And he said, "You're out of here. Don't come on this property anymore. I never want to see you again or your clients. They're not going to get the property. I'm terminating right now. You are just, I'm done," kind of thing. The buyers actually came back and told the builder, "I don't know why our buyer agent did that." And the buyer agent proved to them in an email, and the builder saw it. And the builder said, "Yeah, I kind of figured, I'm sorry I took it out on you, but I just had enough with your buyers," right? So the buyers and the builder made peace regarding it. The buyer agent terminated their agreement, but they got paid because, see, they're on the contract. And this buyer, they proved that the buyer lied and was willing to say all these bad things about their buyer agent when all they were doing was following the instructions in writing that the buyers had asked the buyer agent to do. So almost all the builder contracts have those types of provisions. So you have to kind of be careful about that. Now, 9, if the sales rep makes a statement, right? They're so nice, those on-site salespeople. They're just delightful people. Or say the construction supervisor or superintendent, right? Anybody who makes a statement to the buyer, the buyers can't rely upon it, ever. It's what's in the written contract that will be binding. And many of the contracts state that, no matter whatever anybody else said to you, we're only required to comply with what we have both agreed to in writing on something like that. In case in point, when the buyers freaked out when they saw the utility boxes that were placed in a spot in the backyard that they didn't like, the buyer agent and buyers met with this on-site person, and the salesperson said, no problem, we're going to get them moved. Well, they couldn't get them moved. And the buyers had recorded what the salesperson said, and the builder came back and said, I told you in the contract, you absolutely understand that I'm not required to move them. I'm not required to give you a concession for this or anything like that. And they were saying, well, your salesperson lulled us into believing that blah, 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 all these types of things. And yes, I could see where that would happen. They're very nice people. They're accommodating, but they work for the builder folks. Okay. A lot of construction people are saying, I don't want you in my face. I don't want you around. I'll take care of it, right? The blue tape phases, all those types of things. Some of the contracts have a be informed addendum for the buyers to sign and acknowledge. If you look at it, it could be comparable to what our general notice and information to consumers is, right? The form that has got all different provisions that really will touch a real estate transaction. And this be informed addendum is almost like the cliff notes of what the builder really wants the buyers, right, to understand that they need to read this and accept it, because once you sign that contract, you've been told on something like that. So we've seen that type of instruction. Some builders' contracts are 80-something pages long, right? We have trouble with just getting a buyer to acknowledge a one-page form, right, on something like that. So again, it is different for every builder, but you just need to understand some of the highlights that buyers will need to get confirmed and have it in writing if there's any issue on it. They need to understand that they have a right before they sign that contract, not only to consult a real estate attorney, but also to negotiate properly, make sure everything is in writing on the contract. And 10, buyers always need to inspect the property. No buyer is ever going to be told by our buyer agent, you don't need to do it. The builder's given you a 1 year. I don't think so. Those agents have been caught in a bad situation when they said that. The reason for that is there's a sense of urgency on the builder to get certain things done prior to closing that the buyer has found on a truck inspection report or other inspectors that are licensed to inspect, right? The builder has to get all that taken care of because now it's brought to their attention and they've agreed to do that, right? Once the buyer has closed on the property and they contact the customer service area for certain things, our buyers have found some builders, there's no sense of urgency, right? Buyers think, oh, you need to come over today and fix this. And they're kind of like, well, you're in the queue. And as soon as we have that one back out here, about that kind of thing. And that's usually what happens when you delay making sure that you get the property inspected properly and get all those things taken care of that can be based on the inspection report that the buyer has given to the builder. Now, some builders do require insurance thresholds for anyone to step on their property and inspect. Some builders say, I have to have the certificate of insurance from this inspector. They have to have certain limits of liability. I won't let them on. So those kinds of concerns could be there. Some of those are already in the contract. So a buyer absolutely understands that they are compelled to follow those provisions. No truck inspector can just come out to a builder's property and say, I'm here. They would have to meet what the builder has required from any inspector that's done that. And finally, just as I started out, buyers need to know in writing, builder contracts favor the builder only. They're written by their attorneys. They have all these pages, countless pages, and a buyer just really wants what? I just want an initial signing date, give my cashier's check, wire the money, and I want to have a contract and I want to buy that property. They're not thinking of the obligations that a builder may have in a builder contract versus our truck promulgated forms on something like that. So while buyer's agents and while I really want to protect the buyer, you can't protect the buyer. That's not your job. Your buyer agent job is to provide a fiduciary service. You can't interpret the the builder's contracts, our TREC contract forms. We know them. We understand the provisions. We can explain all those provisions. That is not the case with a builder's contract. So just be real careful. It's a wonderful time. As I said, builders are sending out things. I get them daily. I got 4 or 5 yesterday, not only for great interest rate for buyers, but also various incentives. So it's a great time to think of builders' homes for your buyers. But I needed to provide some of the highlights because we've had some issues with this, and they try and come after the buyer agent when it was clear that the buyer had agreed in writing with the builder for certain provisions on something like that. Okay, let's see. We got any questions? Okay, let me see.
Marilyn, I have a question.
Okay.
Yes, ma'am. I just need a little bit of clarity on the signage for the open houses. I was just wondering, can I put my sign on median and pick it up like 3 hours later after open house?
Are you talking about your directional sign?
Correct. Like open sign arrows. Correct.
You would be subject to penalties. So you probably want to just verify that it's okay. As I said, every place we go, municipalities are different and certain counties are different. So you just want to verify all of that. But typically, they don't bother it if you're timely, right? If you put it out for so many hours and then pick it up.
Okay. Thank you.
Okay. Let's see what's in chat. When will we be required to use a critical date list? You're not required to, it's just optional. But if you're a fiduciary, you will have that form or my Excel spreadsheet or some form that you created where you've assisted the buyer by pulling out those dates. Do we have a list of lawyers that we can refer our buyers to for these various issues? Are you talking about the foreign parties, Mary? If you are, then that's referencing probably immigration attorney specialist on something like that. I don't have a list of that. I can talk to our
Immigration.
Yes, immigration attorneys probably would be the best source on something like that. But I'll ask our attorneys if they'd be willing to let us know who they might recommend for something like that. I'm just going to tell you. Attorneys' fees are, especially real estate professionals, attorneys, they're extensive, right? And it is costly for them, but again, I'll try and find a list that we can give for you. Can you confirm the current requirement regarding permits for door knocking solicitation, especially with recent strengthening enforcement? No, but there are provisions. You can't cross a sign and that type of thing. So I couldn't speak to Missouri City and Sugar Land. You'll have to do that on your own. I'm sorry about that. Where can we find your Excel spreadsheet? Norman, where is it, honey? Norman will come and address that, where you can find that. See, it can't.
The calendar.
Is it in the calendar?
Yes.
Okay, great. Thank you so much. Why would we need to use the compensation agreement between brokers when the list? You don't. You can only use that when there is compensation that the listing broker has received permission by the seller to share. That's the only time that you can use that.
Where would it be listed in the listing agreement?
It's either 5A or 5B right now. 5B says I can't share, 5A says I can share. It's only if it's in 5A would you do a compensation agreement between brokers when a prospect comes.
And with the proposed changes, there will only be 5A, correct?
Yeah. Mm-hmm. It says very clearly the language, it's intended That means it's meant to not include buyer's compensation or the ability for the listing broker to share.
So if these changes are accepted and then we only have 5A, it will only be the listing broker's portion, correct?
Correct.
And then how will the compensation agreement between brokers tie into that at
It
that
won't.
There
It
won't be
won't
way
one.
that
No. See, that's the intention is to eliminate it, right? They can't eliminate it now because we have a lot of listing agreements where the parties have agreed to 5A, which says I'm going to share and the seller has given me permission to share.
Marilyn, for clarity, does that mean from now on, as we submit purchase offers in the 1 to 4 contract, should we use 12A 1B?
That has been my determination since I found out all these agents don't know how to use any of the forms.
Thank you for that clarity.
Yeah. I cannot tell you, last time I said, I've been asked 10,000 times about compensation, and I always assumed that that would be the first thing you would get down right. That there would be no questions about it once Trek approved that form, right?
Right.
Because it took away our addendum for brokers fees that Texas Realtors had to put in place so that we could continue to function after the NAR settlement went in August of 2024. So the resolution for only having the proposed provision in 5A in the listing agreement that's proposed changes is direct related to sellers not ever being able to sue you because you had compensation. You were falsely inflating what it cost me to sell this property because you're helping that buyer agent get money from me.
Understood.
will you elaborate if these changes are accepted in the listing agreement and 5A is the only option? If the seller does authorize the disclosure that the seller is paying buyer expenses, it would be split out in 12A 1B and C, what the seller has agreed to?
It's that way right now.
Right, okay.
12A1B is compensation the buyer's asking the seller to pay for
Correct.
their buyer brokerage.
Okay.
12A1C are other buyer expenses.
In other words, we will not have a page 10 section.
Oh, yeah,
That-
no. And I showed
that'll be
you that
gone.
form looks
Mhm.
very different. There is no disclosure on
Very
the
well.
new Trek promulgated form.
Okay. Existing listings, once this goes into action, will we need to get replace old listing agreements with the new one?
You don't have to, no, sir.
Okay, thank you.
Mhm. It says, do we need to use any form while doing an open house? Right now, when you do an open house, you're at the seller's direction that you're at the open house. The only thing I mentioned to you, and I talked about that last time, is your open house register, right? Command has some. Norman, have you seen those in Command that they have? They've given you a template of an open house register, which allows anybody coming in to sign in and then opt in or opt out for you contacting them and ask if you are currently working with a realtor, all the great things on something like that. But at this point in time, you don't need any special form other than your open house register when you are representing and sitting on an open house for this listing, for the brokerage listings.
And yet in order for us to confidently and legally follow up with those leads, if you will, we need them to opt in to further communication.
Yes, correct. It has to be transparent. The communications permission to communicate with them has to be given by them. And so that's why that open house register has, are you currently working with a realtor and would you accept future communications? And they define what the communications could be like. It could be automated, it could be by email, by text, those types of things on something like that.
Could we go back to the hard 300 for a minute?
Okay, what about it?
In the coming soon, where it says 3B. It's not displayed on har.com. If you are a platinum agent and you share your branded app with the client, they can see all the coming soon status through that.
Right.
But that still is being defined, even though people can see it, it's in a coming soon status. That still is.
Yeah, any of your clients, anybody that you have access to MLS, any of your clients would have access to all the coming soon. Just can't share it. You can't show it until it becomes active.
And we have a sign in the yard for those 21 days?
You are able to publicly market the property.
100%. Great.
I guess
Thank
I'm
you.
confused because it's saying it is not in 3B. It says it is not displayed on HAR.
Um,
There should be two selections.
Here we go. Coming soon is available to anyone. It's only visible to real estate professionals that have access to MLS, and their clients will know it. It won't be on HAR.com or other real estate websites while in coming soon.
Okay, that one's just throwing me off because that's where our clients can see it is in har.com. So that was
Only those who we have set up on a listing alert.
Right.
correct.
And those are your clients.
Okay.
Mhm.
Mhm. Okay. Let's see if I got here. How can I get the register to work when there is no internet connectivity at the open house?
Print it out and get people to write it down.
There you go, the old-fashioned way. When in doubt, yeah. The showing form does not take the place of the TXR 1417. That representation disclosure is a confirmation that you've told the prospect that you don't represent them and that you only represent the sellers. So the representation disclosure is very different than a showing form because the showing form says I don't represent anybody. It's real clean. It's just a showing form. Okay. Any other questions? And Norman just put the link in for the time limits that I have on the Excel spreadsheet for you. Norman, you are awesome.
Hey, sorry about that. I had to run off to go help somebody.
I bet you did. Norman is always there for us. He is very, very busy and active and always taking care of all of us. Thank you,
Marilyn.
Jody. I really appreciate that.
Marilyn, on the TCPA scenario situation, is there a way that we can, how do I say this? Can we still circle prospect?
Can you still what?
Circle prospect? Can we still call neighbors of listings, inviting them to the open house, notifying them of the house for sale? Is this considered solicitation? Are we in danger if we are doing such a thing?
Yeah, you have to be careful on that type of thing. Many times agents send something out that's in the mail, right? Or let them know that. On something like that, you would have a way for them to contact you and say, don't further contact me, right? That type of thing. The biggest thing is they have the ability to opt out. If you contacted them and said, you can never contact anybody on any do not call list, period, without their written authorization. And so that would be the risk. You would have to vet all of them and make sure they're not on any of the do not call list.
And given they're not on any of the do not call list, are they still quote unquote fair game to call and invite? Would you
It
say?
could be, but just make sure that if they tell you never to call them again, that you put them on the list and also on the list for the office.
Fair enough. Thank you.
Yeah. So much of what we do is the methodology that we use to promote our listings, right? And as I said, we used to have things that we'd send out, inviting all the neighbors to, if they have people that they know or want. You can send an email, but the minute that party comes back to you and says what, there has to be an easy way for them to opt out of receiving future emails from you.
Okay. And yet a phone call doesn't have such a thing. I mean, they have their voice where they can easily say,
And
stop calling me.
And all they have to do is tell you, stop this, and you will put that down on your do not call list as well as the office.
Very well. Very well. Thank you.
So what am I going to do next time? I took up an hour and a half of your precious day, and you can see how much we have to be aware right now because of all the changes that are going on. Next time that we meet, we will have gotten the results from the broker lawyer committee that is meeting on October 10th. So we're going to know if they tweak some of the forms or if they decided to table some of them, and they'll look at them later on those type of things. But we'll have a good idea that what TREC's going to approve on November 4th. And so we'll be in preparation for it. At some point, I also want to talk to you about all the lease changes. We do a lot of leases, and some of you just don't do them properly. And it really scares me when I review these leases and see things that aren't completed as a listing agent, and your name is on that lease that you created the form, and it's not complete, it's not accurate. The legal definitions of a tenant and an occupant are very different. You know, when I see egregious errors, we need to do a better job, right? We want to make sure that we don't get caught up in something like that. So we have issues with leases as well. So I want to show you what Texas Realtors is proposing and when it's going to go into place. And I'll probably do that next time, just like I snuck in the builders things today. All right, good people, please stay safe and well. I can't believe it's the end of October, but let's make this a great year and finish out the year well. Okay? Take care.
Thank you,
everybody.
Marilyn.
Thank
You're
you.
welcome, hon.